Equal Employment Opportunity, Title VII of the Civil Rights Act. Equal employment opportunity is the condition in which all individuals have an equal chance for employment, regardless of their race, color, religion, sex, age, disability, or national origin. The federal government's efforts include constitutional amendments, legislation, executive orders, and court decisions that interpret the laws. Major equal employment opportunity laws and regulations. The Equal Pay Act of 1963 requires that men and women performing equal jobs receive equal pay. Title VII of the Civil Rights Act forbids discrimination based on race, color, religion, sex, or national origin. Age Discrimination in Employment Act of 1967 prohibits discrimination in employment against individuals 40 years of age and older. Rehabilitation Act of 1973 requires affirmative action in the employment of individuals with disabilities. Pregnancy Discrimination Act of 1978 treats discrimination based on pregnancy-related conditions as illegal sex discrimination. Americans with Disabilities Act of 1990 prohibits discrimination against individuals with disabilities. And the Genetic Information Non-Discrimination Act of 2008 prohibits discrimination because of genetic information. Title VII of the Civil Rights Act of 1964. This is the major law regulating equal employment opportunity in the United States. It's enforced by the Equal Employment Opportunity Commission and was written by Congress during the Civil Rights Movement. It was signed into law by President Lyndon B. Johnson and prohibits employers from discriminating against individuals based on race, color, religion, sex, or national origin. Employers may not use race, color, religion, sex, or national origin as reasons not to hire someone, to fire someone, or for discriminating against them in terms of pay, employment conditions, or privilege of employment. May not be used to limit, segregate, or classify employees or applicants in any way that could deprive them of employment opportunities. This applies to organizations with 15 or more employees who work 20 or more weeks per year. The Civil Rights Act of 1991. This is an amendment to numerous equal employment opportunity laws and regulations, including Title VII of the Civil Rights Act of 1964 and the Civil Rights Act of 1886. This amendment added compensatory and punitive damages in cases of discrimination. Prior to this amendment, damage claims were limited to equitable relief, which entails back pay, lost benefits, front pay under some circumstances, as well as attorney fees and costs. The limit on punitive damages ranges from $50,000 to $300,000 and is determined by the size of the organization involved in the suit. Equal Employment Opportunity Commission versus Abercrombie and Fitch. In 2009, the Equal Employment Opportunity Commission filed suit on behalf of Samantha Eloff against Abercrombie and Fitch Stores, Inc. Eloff had been interviewed for a position at one of the company's stores in 2008 and was denied the job based on the fact that she was wearing a headscarf. The Equal Employment Opportunity Commission stated that the refusal of Abercrombie and Fitch to hire Ms. Eloff was a violation of Title VII of the Civil Rights Act of 1964, which prohibits prospective employers refusing to hire an applicant because of the applicant's religious practices when the practice could be accommodated without undue hardship. In 2008, Abercrombie & Fitch interviewed Eloff and gave her a rating that qualified her to be employed by the company. The interviewing assistant manager, Heather Cook, was concerned with Eloff's headscarf, fearing it went against the store's look policy, which forbade caps. Cook then consulted the store manager, seeking clarification as to whether or not the headscarf qualified as a cap. The store manager directed Cook not to hire Eloff, despite being informed that the headscarf was most likely worn out of religious practice. the Equal Employment Opportunity Commission sued Abercrombie & Fitch for violation of Title VII of the Civil Rights Act in 2009. In a jury trial, Samantha Eloff was awarded $20,000 in damages. However, the verdict was reversed by the United States Court of Appeals 10th Circuit on the grounds that she had not stated to Abercrombie & Fitch as to the reasoning she wore the headscarf. The case got brought to the Supreme Court, and Justice Scalia wrote under Title VII of the Civil Rights Act of 1964, an employer may not make an applicant's religious practice, confirmed or otherwise, a factor in employment decisions. Continuing on, Justice Scalia stated, the law requires not simply that religious practices be treated no worse than other practices, but they receive favored treatment. The only exception to this law is when a business can prove that by accommodating the religious practice, it would create an undue hardship. On June 1, 2015, 7 years after the interview, the Supreme Court ruled almost unanimously in favor of Samantha Eloff and reversed the order of the 10th Circuit. The Supreme Court ruled that an employer may not refuse to hire an applicant if the employer did so to avoid making religious accommodations. Abercrombie & Fitch paid $25,670 in damages to Samantha Eloff, as well as $18,983 in court fees. Since the case, Abercrombie & Fitch has loosened its dress code and now grants requests for religious accommodations, including wearing hijabs. The case involving Samantha Eloff was not a first for Abercrombie & Fitch. In September of 2013, U.S. District Judge Yvonne Gonzalez-Rogers found Abercrombie & Fitch liable for religious discrimination in a case similar to the one involving Samantha Eloff. A San Francisco store fired a Muslim stockroom employee for refusing to remove her hijab. In another case, in April of 2013, an 18-year-old job applicant was denied employment at a California store after being questioned about her headscarf and religion during an interview. The Equal Employment Opportunity Commission and Abercrombie agreed upon consolidating the two cases. Abercrombie was ordered to create an appeals for denial of religious accommodation, as well as inform applicants that religious accommodations to their look policy may be available, and include headscarf scenarios in all manager trainings. Lastly, Abercrombie is to pay both plaintiffs a settlement of $71,000. In closing, despite being involved in numerous suits similar to that of the one with Samantha Eloff, Abercrombie & Fitch was still found to be in violation of Title VII of the Civil Rights Act of 1964. In the end, justice prevails, as with each of these cases, Abercrombie & Fitch was held liable for their actions, and Title VII was upheld.